The year is 1494, and a criminal trial is taking place in the French town of Clermont. The defendant has been brought before a judge and stands accused of the crime of murder. The audience is horrified to hear the details of the crime as they are read aloud. A child has been murdered, the son of a local cowherd named Jean L'Enfant and his wife, Guillaume. The crime is made even more ghastly by the brutality of the act. The court hears that the child was strangled and defaced in his crib whilst his parents were out, performing errands. The defendant had been caught in the act, having inflicted severe wounds to the child's face and neck, wounds that would quickly prove fatal. Not only was the awful act committed within the family's home, but it also took place on Easter Sunday, a holy day of celebration. Having examined the evidence given by the prosecutor, a licentiate in law by the name of Jean Levossier, the judge finds the defendant guilty of murdering the child and sentences them to death by hanging. An unpleasant affair to be sure, but this is a pretty standard example of justice in early modern France, right? Well, if you had been present during the trial on that day, you would have immediately noticed something rather unusual. The defendant was a pig. I'm sure you saw that twist coming, given the title of this video. But what's really unusual about this trial is that it wasn't really that unusual, at least not in pre-modern Europe. Now don't get me wrong, animal trials weren't exactly commonplace occurrences, but they did occur frequently enough in medieval and early modern Europe that they're considered a noteworthy phenomenon. In his 1906 book, The Criminal Prosecution and Capital Punishment of Animals, American scholar Edward Payson Evans counts 191 recorded animal trials that took place between the 9th and 20th centuries CE, occurring mainly, though not exclusively, in Europe, with a significant number of the trials taking place in France. The earliest account of an animal trial recorded by Evans took place in the Valley of Aosta in Italy in the year 824 CE, and the defendants were moles. The most recent animal trial Evans recorded took place the same year as the book's publication, 1906, and occurred in Delémont, Switzerland. In this case, a man, his son, and their dog were charged with the robbery and murder of a man named Marja. The dog was charged along with its owners due to its fierce participation in the act. The two men were sentenced to life imprisonment, and the dog was sentenced to death. Though it must be said that this particular case was extremely unusual in this time period, and that the frequency of animal trials, peaking between the 13th and 17th centuries, had dramatically decreased by the mid-18th century. Though a wide array of animals were tried for a whole host of crimes, pigs appear to have been the most common defendants. Domestic pigs aren't especially aggressive, but they are opportunistic scavengers and, being omnivores, will consume human flesh if it is convenient to do so. If you've seen the movie Snatch, a certain character may come to mind.
Then I hear the best thing to do is feed them to pigs. You've got to starve the pigs for a few days, then the sight of a chopped up body will look like curry to a pisshead.
Domestic pig attacks are uncommon, but certainly not unheard of, and in pre-industrial farming communities, pigs were often allowed to roam about and feed on human refuse and whatever they could forage. I'm sure you can imagine how an unattended infant might look to a hungry pig. Infanticide is a charge that seems to come up a fair bit during the trials of pigs. In December of 1457, a sow and her 6 piglets were put on trial in the town of Savigny, located in the Duchy of Burgundy, modern-day France, charged with the murder of 5-year-old Jean Martin. The sow was found guilty and sentenced to death by hanging, though by the feet rather than the neck, as was Burgundian custom. The pig's owner was charged with negligence, but escaped punishment, and so did the 6 piglets. The judge ruled that, despite being found covered in blood, the court could not prove that the piglets had partaken in their mother's crime. This trial involved a judge, 2 prosecutors, including a counsellor to the Duke of Burgundy, and more than 8 witnesses. And yet Professor Esther Cohen, in her work Law, Folklore and Animal Law, writes that this event was typical in its painstaking insistence on the observance of legal custom and proper judicial procedure. In other words, these were not show trials. They were conducted with all the seriousness and diligence that would usually be afforded to a normal criminal trial. Edward Evans records jailers and executioners charging the same amount for imprisoning and executing an animal as they would a man. But what's up with all of this anyway? Why bother putting an animal on trial? Is it even possible for an animal to commit a crime? Well, most modern justice systems say no. Animals lack moral agency, and therefore cannot knowingly break the law. Though animals can be confiscated and euthanized by the authorities, they are not themselves considered legally guilty of any crime. If, say, a dog attacks a child, that dog may be confiscated and destroyed, but it would be the owner of the dog who would be the target of any legal prosecution if such actions are deemed necessary. But clearly this was not always the case. No one is certain as to why animal trials took place, but there are numerous theories. The role of public punishment, a different legal view of moral culpability, and the increased role of religion in society are all key factors, but historian Peter Dinzelbacher offers a more definitive answer. In his 2002 article, Animal Trials, a Multidisciplinary Approach, he writes, "These trials took place only under extremely unusual circumstances, in order to help the local community cope with an otherwise recalcitrant threat, not because they were proven to work, but because they created the impression that the authorities were assiduously maintaining law and order in a cooperative and decided manner." Now, this makes quite a lot of sense in my opinion. Even today, when a disaster strikes, the authorities must be seen to be proactively seeking the cause of said disaster, and, if need be, bring any culprits to justice, in order to appease the public and maintain law and order. Should the authorities fail to act, the public will begin to lose faith in them, and civil unrest can be expected, even if the disaster is not man-made. We see this happen quite a lot in the modern day, especially with the ever-increasing number of natural disasters. Though we don't expect the authorities to drag animals before a court of law, tragedies caused by animals have led to the introduction of legislation regarding said animals. For example, in 1991, a string of violent and highly publicised dog attacks in the United Kingdom led to the introduction of the Dangerous Dogs Act, regulating the ownership and breeding of dogs belonging to types bred for fighting, most notably the Pit Bull Terrier and Tosa Inu. In fact, in 2023, the UK government decided to institute a ban on the American Bully XL breed due to a string of attacks that prompted huge media attention here and quite a bit of public outcry. But that's enough about the modern day. I'm sure you get the idea. Let's look at another animal trial. In the year 1474, in the town of Basel in Switzerland, a chicken stood accused of the heinous and unnatural crime of laying an egg. So what? Well, it appeared that a rooster, a male chicken, laid the egg, and this is a big deal to the authorities. It was believed that an egg produced by a male chicken was a foul thing indeed, and that a fearsome monster called a cockatrice, or basilisk, may hatch from such an unnatural egg. Witches and warlocks may also employ such eggs in their rituals, and thus the presence of a rooster who produced such frightful eggs in violation of natural law could not be countenanced. The prosecution argued that the rooster must have made a pact with the devil, and was thus guilty of the crime of sorcery. Now, I previously mentioned that these trials were taken seriously. Well, here's a good example of that. This rooster actually had legal representation in court. The lawyer appointed to defend the chicken argued that no man nor beast had yet been harmed, and that the laying of an egg was an involuntary act, not illegal in itself, and indicated no malice on the part of the chicken. Furthermore, the chicken could not be guilty of the crime of sorcery, as there was no recorded instance of Satan ever striking a deal with an animal. Fair enough, but the prosecution instead argued that the rooster had been possessed by the devil, and cited the story of the Gadarene swine from the New Testament as a written instance of this occurring. In this story, which is recorded in the Gospels of Matthew, Mark, and Luke, Jesus came across a man in the region of the Gerasenes who was possessed by a multitude of demons, causing the man and his community a great deal of distress. After speaking with the demons, who identified themselves as Legion, Jesus drove the demons out of the man and into a nearby herd of pigs, apparently 2,000 in number. These pigs, driven mad by their demonic possession, rushed into the sea and drowned. The grateful man, freed from the demons, asked to follow Jesus, who instead bade him remain and tell of the great things that the Lord had done. The prosecutor argued that, though these pigs were involuntary agents of evil, they were still punished, and therefore the rooster must be punished too. This appears to have convinced the judge, and the rooster was sentenced to death by burning at the stake. The sentence was carried out in the Kublenberg, or public square, and the poor animal and its egg were burned in front of a large crowd of spectators. But that still begs the question, how did a rooster lay an egg? Well, we can't know for sure, but it seems highly likely that this chicken was a gynandromorph. Thanks to modern science, we now know that mature hens can sometimes acquire a rooster's secondary male sex organs, notably the large comb and wattles, and they may even start crowing. I won't get into it, but it's usually to do with the hen's ovaries, and the result is a chicken that is essentially a rooster, but usually not one that retains any reproductive function. The rooster of Basel appears to be an exception. While this poor chicken's lawyer wasn't able to get it acquitted, there are cases where the accused animal does actually get let off the hook. In 1750, a Frenchman named Jacques Ferron was caught getting intimate with a jenny, that is, a female donkey. As was the norm, both Ferron and the donkey were charged with bestiality. Ferron was found guilty of the crime and sentenced to death by hanging. The donkey, however, was spared the noose due to the intervention of the local community. During the trial, the parish priest and several witnesses wrote a letter to the court claiming that the donkey had a virtuous nature and was surely not a willing participant in Ferron's perverted crime. Fortunately, the judge agreed with the assessment and the donkey was acquitted. No such luck for Monsieur Ferron. So we've talked about pigs, chickens and donkeys, but these are domesticated animals. What about the non-domesticated ones? Well, now we enter the jurisdiction of the religious courts. Bizarrely, the prosecution of rats, mice, locusts, weevils, and other animals we typically consider pests was undertaken by church authorities. This is because such animals are not employed in the service of man, and are therefore not under the control of any earthly force. Thus is the authority of the church required, as it is believed that they have some degree of influence over the supernatural. Excommunication or exorcism were the typical punishments levied upon swarms of pest animals by the church. While it might seem pointless to exclude a group of rats from receiving communion, this form of excommunication was a more grave type, declaring the animals anathema. Sometimes referred to as major excommunication, this not only prohibited the excommunicated from receiving the Eucharist and participating in Christian services, but also expelled them entirely from Christian society. It was believed that anathematizing such animals may draw the aid of God, who would drive such spiritually deficient creatures away from his faithful community. That is, provided they were found guilty. See, one benefit of being tried in an ecclesiastical court is that the church authorities often provided the accused with a lawyer to defend them, which brings us to our next tale. The year is 1522, and we find ourselves once again in France, and once again in Burgundy, this time in the city of Autun. Disaster has struck. Rats have found their way into the barley stores that supply the region and destroyed a great deal of the grain stockpile. This is quite a serious problem, as grain stockpiles were critical in ensuring the survival of communities during the winter months and in the event of crop failure. Thus, an ecclesiastical council was convened, and the rats were charged with the destruction of the barley crop. The rats were issued a legal summons, with the threat of trial in absentia should they not comply. As you can imagine, this was usually the case in such trials, and the pests were generally judged guilty in absentia. I say generally, because in this case, a lawyer by the name of Bartholomew de Chasseneux was appointed the task of defending the rats in their upcoming trial. Now this account comes from our friend Edward Evans in 1906, but he cites Berriat-Saint-Prix's 1820 work, Themi Jurisconsulte, Edme Theodore Borg's 1828 Dictionnaire de la Penalty dans tous les parties du monde, and de Chasseneux's own 1531 treatise, with the very concise and easy to remember title, The First Plan, which can rightly be called a treatise because of the complex and hidden teaching, where that question is clearly and accurately treated on the excommunication of animals and insects. While de Chasseneux doesn't specifically mention any of the animal trials he was allegedly involved in, he discusses the topic in great detail, so we can safely assume that he had some experience with them. Anyways, the rats, surprise surprise, didn't show up for court. Given that this was expected, the court moved to proceed with the trial, leading to the seemingly inevitable guilty verdict and the subsequent excommunication. However, de Chasseneux, taking his new posting quite seriously, argued that his clients resided in a wide geographic area occupying a variety of local villages, and therefore a single legal summons was insufficient in notifying all the rats that they were to attend court. The court accepted this motion, and a second summons was issued, this time to be read from the pulpits of all local churches. This was deemed to be an adequate measure, and a good length of time was allotted to put this plan into action. After this time had elapsed and the summons were duly issued from all local parishes, the court convened and noted that, once again, the defendants had not shown up to court. But the immortal souls of the rats were spared once again when de Chasseneux objected and argued that the rats could not be expected to appear in court. While you might think that this is the moment when de Chasseneux would state the obvious and say, they're not coming because, well, they're rats, and rats don't speak French or Latin, nor do they understand the concept of law. No, de Chasseneux had a better idea. He argued that his clients likely had every intention of attending their trial. However, they could not, as the journey facing them was simply too long and dangerous to be embarked upon. You see, rats have a mortal enemy that prowls the land, making travel impossible, and that is the cat. Cats, owned by many villagers and occupants of Autun, are unceasingly vigilant and lie in wait to ambush any rats that cross their path, so argued de Chasseneux. And therefore no rat can seriously be expected to risk their life setting out on such a journey with these creatures potentially lurking around every corner. Evans summarises de Chasseneux's lengthy address to the court. If a person be cited to appear at a place to which he cannot come with safety, he may exercise the right of appeal and refuse to obey the writ, even though such appeal be expressly precluded in the summons. The point was argued as seriously as though it were a question of family feud between Capulet and Montague in Verona, or Colonna and Orsini in Rome. Now I wish I could tell you for certain how this trial ended, but we don't really know for sure. There are no records of the rats of Autun being anathematized, and it seems likely that the rats were either acquitted or the trial was called off entirely, probably because, at this point, the court were getting sick of de Chasseneux and his rats. In any case, de Chasseneux began to gain a reputation as an extremely capable legal mind. In a later case, at least according to Evans, de Chasseneux, while working as the high judge of the court in Provençal, once spared a group of Vaudois heretics, more commonly known as Valdensians, that he had ruled against when a friend begged him to consider his defence of the rats, arguing that the heretics were not offered adequate protection. De Chasseneux was moved by this and granted clemency to the heretics, though this would only prove a stay of execution, as the Valdensians were slaughtered on the orders of Francis I of France during the 1545 Medindol massacre. De Chasseneux had died 4 years earlier, in 1541. While most historians seem to agree with Evans's account of the trial and the clemency de Chasseneux granted the Valdensians, I feel that it is important to mention that this account is far from being confirmed as fact. Even the 1522 date is a bit dubious. I'm not going to go over it all here, but there is an excellent article on the website The Strong Paw of Reason called The Trial of the Rats of Autun on the Prosecution of Animals and Historians, written by Gabriel R., which scrutinises the story and its retelling in great detail. Excellently researched and well worth a read if you want to come to your own conclusion about the veracity of Evans's account. It was a great help in the writing of this segment, and I've stuck a link to it in the description. Anyways, one funny thing I can confirm is that de Chasseneux's aforementioned first treatise on animal excommunication was written in support of the people of the Beaune, who were in the process of prosecuting a swarm of beetles. De Chasseneux argues in his treatise that it is indeed proper to bring animals to trial, and to excommunicate them if they are found guilty. This treatise was the first part of de Chasseneux's three-part Concilia, a sort of practical guide for conducting legal proceedings. Regardless of the truth of de Chasseneux's own participation in the trial of the rats of Autun, his writings on the subject of animal trials show just how seriously these trials were taken. In fact, de Chasseneux actually mentions that Autun had previously tried slugs for crimes against the community, so trying rats isn't exactly out of character for them. Similarly, when vineyard-destroying flies were sued by officials from Saint-Julien-de-Maurienne in 1587, a legal impasse was reached at the trial, which resulted in the flies being offered an alternative but equally enticing piece of land far away from the vineyard, as opposed to excommunication. Animal trials are one of those historical phenomena which initially seem remarkably stupid, surely the product of largely illiterate and heavily superstitious pre-modern societies. But as we've discussed, their true nature is far more complex than that, and we still don't fully understand them. In the days before mass communication, police forces, widespread literacy, and all the benefits and trappings of modern life, the concept of law and order was much more hands-on. Social cohesion and adherence to the law was frequently maintained through visible displays, such as public executions, religious sermons, local festivities, and so on. It was believed, and many still believe, that the world is subject to God's law, and man, as God's favoured creation, holds precedence over all beasts. Justice is universal, and man must govern the natural world by law, so the theory goes. While it is undoubtedly cruel to say burn a chicken to death for the crime of sorcery, to the society that undertook this act, witchcraft was a very real threat, and it was widely believed by the authorities that the populace needed to see that such threats were handled promptly and with all due process, as they did not benefit from a firm understanding of the natural sciences, as we do today. They viewed natural occurrences that defied their understanding of the laws of nature as supernatural, magic, witchery, or divine miracles depending on the context. Though placed beneath man, animals were widely believed to be capable of good as well as evil. See the recurring story of the faithful hound, Ginfor the greyhound in France, Gela the wolfhound in Wales, contrasted with the motives of evil associated with dragons and serpents. The story of St. George and the dragon, for instance. This more anthropomorphic view of animals lent credence to the idea of putting them on trial for criminal acts. In the case of excommunicating vermin, to be honest, there was very little that could realistically be done in the wake of large-scale crop destruction. In the days before industrialized agriculture, effective commercial pesticides, and plentiful modern fertilizers, crop failures and famines were a very real and horrific reality faced by humanity. Starvation is a terrible way to die, not to mention the diseases and social breakdowns associated with famine. Even with all the benefits of modern science and technology, many millions around the world are still affected by these disasters. And in a rapidly changing global climate, these spectres of our past may well return in force. Facing the prospect of famine, if the authorities could not exterminate the pests themselves, which they were no doubt already trying to do, it was left to the church to seek the intercession of the divine. Even today, insurance companies refer to events outside of human control as acts of God, and it is still a relatively common saying that things beyond our control are in God's hands. The trial and excommunication of pests was in a way a physical expression of this. Of course, I'm not defending the decision to drag animals before a court of law, but hopefully providing some measure of understanding to the reasons behind the phenomena. In modern times, the legal status of animals is still something of a hot topic. Animal rights activists believe that, as sentient beings, animals should be entitled to greater legal protections. Edward Payson Evans, whose work we have drawn on a fair bit in this episode, was himself a staunch advocate for animal rights. In the digital age we now live in, the legal status of animals is becoming ever more confusing regarding things like copyright. You don't need to look far to find stories of bizarre modern legal cases involving animals, so in a weird way, we're not as far removed as you might think from those bygone days of dragging pigs into court. Thank you for watching. Please do like this video, subscribe, and hit the bell for more content coming soon. I'll see you later.